who look up to you, who look up to Director Comey, and who take a lesson from what they see. When I heard Director Comey extemporize derogatory investigative information about an uncharged person, I was stunned. Dr. Comey, you've said that the rules against that are there for a reason. Just to make it perfectly clear, could I ask each of you to say, what is the reason that we do not want prosecutors to be discharging derogatory information about uncharged persons?
Senator, my understanding has always been that the purpose behind those rules and norms is that prosecutors speak through charging documents, and that the reason for that is because then the individuals who are charged have an opportunity to have their day in court and defend themselves, whereas public statements about uncharged conduct don't afford that opportunity.
They could move over the line into smearing as opposed into proper judicial conduct, proper investigative and prosecutorial conduct.
They could.
And in fact, even where there is a charged person, do you not disclose derogatory investigative information only through pleadings and arguments, and you would not approve of a press conference just adding in some derogatory investigative information outside of the proper channels of the prosecution?
In the charged conduct context, we try very hard to make sure that our public statements stay within the four corners of charging documents until the case has reached a conclusion, and then maybe we'd be talking about the evidence at trial or something like that.
Mr. Horowitz?
In fact, as you know, as having been a U.S. attorney, what was interesting as we went and did this review is there is a department rule that makes clear that the department can't speak publicly about an unindicted co-conspirator. In other words, an individual about whom the department has concluded is in fact a co-conspirator in a criminal enterprise but wasn't charged. But it doesn't have a rule about an individual who's never charged. And that's why we make the recommendation.
That it has that norm, and that norm was correct. Director Comey violated. I don't believe that if he had not violated that norm, he would have ever been up testifying in Congress. It is bizarre to have the director of the FBI testifying in Congress about a case, particularly one that may continue. And I don't think if he'd stuck to the rules, there would have been anything for Congress to look into. He just would have said, we don't discuss cases, we don't discuss investigative information, we worked hard, we made the finding that we made, and that's the end of it. And if he hadn't had all that conversation up in Congress, I don't think he would have felt the same way about the Wiener laptop information, and that second disclosure of derogatory investigative information would not have taken place. So, for want of a nail, all of this unraveled, I think, to the great detriment of Director Comey's reputation, which had been very good, and to the reputation of the FBI, I'm sorry to say, and I thank you for your efforts to have to put this back together, Director Wray. If political advantage to President Trump, then candidate Trump, was not Director Comey's motivation in making those statements, and if it's corollary, political damage to Secretary Clinton was not Director Comey's motive in making that statement on July 5th, what was, to the best of your knowledge?
Well, what we describe here is his explanation being that he thought there needed to be unusual transparency given the unusual nature of the case, the high profile of the case, and his belief that the integrity of the FBI and the Justice Department depended on being able to stand out there and explain what the decision was, why the decision was made, and that he was uniquely situated to be able to do that.
Do you find that credible?
That he believed that, yes.
That he was right?
That he was right about that, no. As we lay out here, That's the responsibility of the Attorney General or the Deputy Attorney General. The highest ranking, whether it's the U.S. Attorney, the highest ranking prosecutor has to make that decision. Under our system, they're the ones who are accountable to the public, to this committee, to the organization.
Did you come across any evidence that would refute the notion that he was concerned about his own reputation and wanted to look balanced in going about this rather than following the rules?
We got a variety of testimony, to be fair, on that. That was in various places as to why he did what he did, the integrity of the FBI and the organization, and really a series of explanations from individuals as to what they believed.
Director Wray, a general question. When should criminal investigations be wrapped up?
It's hard to answer that in a general way. I think when the work is done, is the most shorthanded way of putting it.
How often is legislative opinion about when a criminal investigation should be wrapped up a proper factor to consider in wrapping up the investigation?
It's hard for me to think of a situation where that's a factor we would consider.
I can't think of one either. I agree with you. How often is a subject's lawyer's opinion on when an investigation should be wrapped up a proper factor to determine the wrapping up of a criminal investigation?
That one's even harder for me to imagine.
Yeah. And in fact, I suspect it would be pretty hard for United States Attorney Giuliani to imagine when he was going after Anthony Salerno for years if Anthony Salerno's lawyers had said to him, it's been a year, time to wrap it up. I just wanted to put that context out there. Finally, with respect to obstruction of justice, which you've said is something that should be taken extremely serious at the federal level, official acts can be evidence of obstruction of justice, correct?
Well, I think that's a legal question that I'll leave to the lawyers.
Would you stop an obstruction of justice investigation if it involved an official act, or would you continue to investigate? That's no bar to proceeding on an obstruction of justice claim, is it? Because the obstruction was also an official act?
Well, again, I'd have to look at the law on the subject, but my impression is that if we had evidence that suggested there was a possible violation of the obstruction statutes, we would continue to investigate it until we'd reach a conclusion.
And a lawyer for a subject can obstruct justice?
A lawyer for a subject can obstruct justice.
Subject of investigation can obstruct justice in the investigation, correct?
Absolutely.
Yeah. Okay, my time's up.
Senator Sass. Thank you, Chairman. Thank you both for being here. Mr. Horowitz, can you remind us who Cheryl Mills and Heather Samuelson are?